All right, enough horsing around. Happy Halloween, everyone. Welcome back to Civil Procedure. Hope people are doing well. Okay, so here we are, October 31st. It's an exciting day, and we are happy to spend it together talking about limitations, right? Okay, so we were talking last time, we're still in disposition without trial, right? So all of our techniques we have, this toolbox of things you can do if you want to win a case early, right? Without having to go all the way to trial. And we've gone through quite a few of these by this point. I think we've done 9 or 10. Let's share an application screen. Okay, yes, we've been through a lot of these, right? We've gone all the way from striking pleadings right down to gag proceedings, and then last time on Tuesday we got into dismissal for delay, which is a mechanism open to defendants who are tired of waiting around for the plaintiff to move the ball down the field. And we saw that Rule 24 is there, and it does give the plaintiff, the defendant, the rights to bring that motion. But we saw that that's a pretty high bar to cross for any defendant, right? You've got to demonstrate prejudice, and you've got to bring a really strong case, because Rule 24 is a draconian motion that ends up, knocking out the plaintiff's case and results in, the court deciding civil litigation without any reference to the actual merits or what actually happened in the real world, which is a really disturbing thing for the system. So it's hard to win a Rule 24 motion. And in fact, in Armstrong versus McCall on Tuesday, we saw a case which had dragged on for almost 9 years with significant delay from the plaintiff, and the defendant still lost, right? So there's a kind of broad sense after Armstrong and McCall that Rule 24 was not necessarily the job done. We are very concerned about delay. This is a big part of the access to justice issue. People think of access to justice in terms of money, and of course it has to do with money, but it also has to do with time, the time cost. If the only way to access justice is to start this process in motion that takes 9 years to get to any substantive resolution, then that is a barrier to justice, just the same way that legal fees are. So we also, another thing about delay, right, and time, is that this too is a factor which permits more strategic abuse of the civil litigation process. Right, so we talked in this material here, right? Section 137, the gag proceedings concept. They talked about strategic lawsuits, and a strategic lawsuit. Well, who can remind us what is a strategic lawsuit? I mean, who can remind us what that's all about? Like, what makes a lawsuit strategic? And that's a bad thing from the system's point of view. Okay, yeah, so Daniel's given us a good example here, right? Taking someone to trial to try to drive them out of financial resources. Yeah, in a sense, but it's not just that, you're trying to bankrupt someone just because you hate them or you're trying to put them out of business. A strategic lawsuit can have a more broad definition as well. Threatening to prolong a suit to scare them into folding their cards. Yeah. So that could be a good one. And Sarah's given us the example of Gian Gomeshi, corporations versus little people. Yeah, so these are all examples, and I think these are all getting to the core idea of a strategic lawsuit. And what's bad about that is that it's a lawsuit which is unlikely to succeed on its merits, and which the litigant knows is unlikely to succeed on its merits. I mean, if you're not engaging in litigation if you have a reasonable expectation that you could actually be vindicated if it were to go to trial. It's strategic if you have no real hope of being vindicated if it were to get to trial, but you're aware that you can win, you can obtain a favorable settlement from your adversary simply by putting your adversary through the ringer, which is the litigation process. This has to do, works most often when you have a power imbalance, right? When you have a deep-pocketed litigant squaring off against a less deep-pocketed litigant. But it can also happen whenever there's anything that's sort of unbalanced between the parties. So some people, some corporations say that they are vulnerable to strategic litigation filed by self-represented litigants, right? So there's some people out there who, for example, think that the Canadian banking system is a corrupt imposition from the capitalist class upon the rest of us, and they may be right, or they may be wrong. But they, because they're self-represented litigants, are able to sue corporations, sue the banks, and they're in a strategically powerful position because if you're a self-rep, you don't have any legal fees, right? And if you're retired or you got a lot of time on your hands and you love being in court, you love being involved in civil litigation, then you can credibly threaten to sue a big bank or other corporation, and it's going to cost them a lot more to defend it than it will cost you to carry it forward, right? And that can be a form of strategic advantage, which then compels the defendant to give you something, even when you have no legal merit to your case. So the idea of strategic advantage in litigation can go both ways, but of course the far more common situation is the one we saw last week in the Fortress case about gag proceedings, right? Where it's in fact a well-versed corporate defendant or corporate plaintiff in that case, which can credibly threaten to strategically use litigation to extract something from the defendant, which no judge would ever give them. Okay, so why am I talking about all that again? Well, just to say that the point about delay, if you have a lot of delay in the litigation system, then that, again, expands the potential for the strategic abuse of litigation. Because if one party is patient, if it's a corporation with sort of a 100-year horizon to sort of plan what it's going to do, and the other party cannot afford to be so patient, then the threat to subject the less patient party to 7 or 8 years of litigation has great strategic power, right? And has great ability to compel that party to make a concession to you that no judge would ever order. All of this just to say that the delay is a big problem, and the system is trying to find ways to deal with it. Rule 24, for the reasons we discussed, didn't seem to be getting the job done. So we ended up with Rule 48.14, which we won't talk about at length, but I did want to point it out because it's kind of another kick at the can, it's another effort the system has made to try to reduce delay and get things going more quickly. So here we have a 5-year limit, right? So any action not set down for trial after 5 years, which is to say 5 years after the statement of claim is filed, is going to be dismissed by the registrar. So this is interesting, right? This is the registrar, of course, is a court official. We have here the court. Anyone remember what this is called? We've talked about this sort of unusual thing that happens sometimes in the rules where the court says we're going to do something without any litigant asking us to do so, without anyone bringing a motion asking for that remedy. I mentioned it briefly when we were talking about motions and contempt motions in particular, sua sponte. So that's the Latin phrase meaning sort of on its own initiative. So this is an example of a sua sponte rule where the court can do it by itself. And the court will do so after 5 years. Your action is officially blown up without you taking any action, unless the parties agree to an extension, right? So they can, if they decide they both want up to 2 years, and they file a timeline, then they can have that extra 2 years. The timeline, you recall, is a specific set of steps in litigation which are going to happen by specific set days, and that's a way to move things along without engaging in drastic remedies like dismissing actions. So that's one way you can get past the 5-year limit. And the other is if the plaintiff goes to what's called a status hearing, which is a motion where you kind of talk about the status of the case, why it's taking so long, why it's legitimate for it to take so long, and why it should not be dismissed. And then at that status hearing, the plaintiff has the burden to show cause why the action should not be dismissed for delay. And you had a short excerpt from the Faris versus Eftimovski case, which gives us our test for this status hearing. To demonstrate that there was an acceptable explanation for the delay and establish that if the action were allowed to proceed, the defendant would suffer no non-compensable prejudice. Okay, so here we're getting back into the same considerations that animated our Rule 24 inquiry. Prejudice, and specifically the prejudice to the defendant. To what extent has the passage of time undermined the ability of the defendant to make a case, to marshal the type of evidence which they would have been able to marshal had the trial actually occurred in a timely way? Okay, so it's still not what you would call fast. We're still talking about 5 years plus a 2-year extension, plus, even if there's no agreed upon extension and the plaintiff can show cause, then they'll still get more time. But it's another tool to bear in mind if you're a defendant and you're looking for ways to bring one of these 7, 8, or 9 year long odysseys to a merciful conclusion. Okay, I think that's all we need to say about that. Faris versus Eftimovski in your readings talks a little bit about the differences between Rule 24 and Rule 48.4, which are pretty much what I've just described. Can you bring an action based on both rules? Okay, yeah, good question. So if you are beyond the 5-year limit, right? So Rule 48.14 is of no use, has no applicability if 5 years have not passed. Interestingly, Rule 24 can be used if no matter how long has passed, right? Remember from last time we said the second way you can win your Rule 24 motion is showing actual prejudice to the defendant, even if a very short period of time has passed. So, if, for example, only a year has passed since the statement of claim, but the plaintiff could have moved faster, and perhaps a key witness that the defendant was relying upon has died or fled the jurisdiction, you might even win a Rule 24 motion with a very short passage of time. 48.14, by contrast, only works after 5 years have passed. So to come back to Natalie's question, if 5 years have passed, would you want to bring would a defendant bring a motion under both of these things? Not really, because this is something that the registrar initiates, right? So the registrar is going to do this on their own initiative, right? Sua sponte. And then the defendant will go to that status hearing, and it's at that status hearing the defendant will make their case about prejudice. If you're then denied, if you lose the status hearing as a defendant, then you might turn to Rule 24 in that case. So we have Rule 24 and Rule 48.14 to try to control and prevent excessive delay by the plaintiff after filing their statement of claim, right? Both of those rules are about the period of time the case officially starts when the statement of claim is filed and served. But what if the plaintiff delays before filing their statement of claim, right? It would be irrational for the rules to pay attention to plaintiff delay after the statement is filed, but completely ignore the delay of the plaintiff up to the point when the statement of claim is filed. Because from the defendant's point of view, the prejudice problems are exactly the same, right? It doesn't matter to you as a defendant whether that time has passed since, where the statement of claim was filed within the period of time that passed. What matters to you is how much time has passed since the actual events giving rise to the civil litigation. Thus enters the Limitations Act, which in the law of limitations requires the plaintiffs to push the case forward with reasonable speed between the events giving rise to the claim and the filing of the statement of claim, right? So limitations is about that period before the statement of claim is filed. And the reasons, of course, are the same, basically, reasons as the ones we've discussed in the context of Rule 24 and 48.14. So a limitation specifically requires a court to dismiss a claim if it's not brought in time, right? That's why it's here within our disposition without trial unit, because the Limitations Act, you would bring a motion. You'd probably bring a motion under this rule, under Rule 21.011A, right, for determination of a question of law. And you would say, look, the Limitations Act precludes the plaintiff bringing this claim forward, so we don't even need to get into the evidence because of the period which has passed since the events in question. So you read excerpts from the Limitations Act and then a case, it's a complex act, right? There's a lot of things going on here, and there's a lot of kind of loopholes. And the Limitations Act is one of those statutes that kind of like gives something to the plaintiff and then says, oh, we've given a bit too much to the plaintiff, so let's give something to the defendant, and they give something back to the plaintiff, and they're trying to walk a line between disciplining and preventing excessive delay and ensuring that as many cases as possible actually are resolved on their merits instead of simply being dismissed on the grounds of how much time has passed. So I think Limitations Act as kind of a bomb, right? So it's a scary, like, Halloween thriller countdown bomb that is attached to a claim, attached to a plaintiff's claim, right? And the plaintiff has to serve that statement of claim before this countdown timer ticks down to 0. Because if they don't, then the bomb explodes, the claim is blown up and cannot be brought forward, right? And lawyers say it's a statute barred claim. If a lawyer says that, that means it's barred by the statute of limitations. Okay, so if limitations are time bombs that are attached to potential claims, then there's 3 big questions we need to ask about those time bombs. First of all, what starts the clock ticking? Secondly, what can delay or pause that clock once it started ticking? And thirdly, of course, how much time is actually on the clock? Okay, so in terms of how much time is on the clock, the key rule you need to know, just to sort of give you the 1,000-level, the 10,000-foot overview of the Limitations Act, and the one thing that I'm hoping you'll remember about this, if you remember nothing else in 5 years, is Section 4, right? That unless this Act provides otherwise, a proceeding shall not be commenced in respect of a claim after the 2nd anniversary of the day on which the claim was discovered. So that's the one which should always be in your mind if you are doing a client intake, right? If someone is talking to you about a claim they might want to bring as a plaintiff, you need to be asking them questions about when the stuff in question happened, and you need to be thinking 2 years ahead of that, because that's going to be the deadline you have to bear in mind. Now, of course, it's more complicated than that, but 2 years, we have a general 2-year limitation is a sort of a rough summary of the law in Ontario. So when does this 2-year clock start ticking? So the key word here is discovered, right? The clock generally starts ticking on the day a claim is discovered in most cases, right? Which is not necessarily the same day as the day on which the allegedly wrongful act or omission occurred. So this is a source of complexity, right? I mean, if we want to put a bomb on claims, a countdown timer, why not just start that countdown timer on whatever moment in time the actually allegedly wrongful act or omission occurs?
Hey, so the concept of discovery is because sometimes a plaintiff might not even know that a harm has occurred. And so on the date that they discover, let's say, in a medical malpractice claim, 5 years after you find out there's a scalpel left in your stomach and there was a 2-year statute of limitations and you could only sue within that 2 years, then you're 3 years too late, but you never even knew that you had a problem to begin with.
Yes, that's right. That's right. And as Kamel says, it would be unfair. It would be deeply unfair to hold plaintiffs responsible for delaying bringing a claim when they don't even know that they have a claim to bring. Okay, so that's why we have to talk about discovery. And our discovery, again, right, we've heard the word discovery already, meaning something completely different when we're talking about the discovery phase in civil litigation, the process of getting the facts out. This is a completely different meaning for exactly the same word. Thank you, gods of civil procedure, for keeping it simple for us. But we have this concept of discovery laid out in section 5 sub 1 sub A. And I think of this in terms of light bulbs going off. I know I got a lot of visual metaphors going on here, but this is how I think of it. So it may or may not be helpful. If just reading the act makes sense to you, then go with that. This is how I think of it. So I think of this in terms of light bulbs going off in the plaintiff's head, right? And 3 light bulbs have to go off in their head before they can be said to have discovered their claim. So first of all, that they have to be aware that the injury, loss, or damage had occurred. Secondly, they have to be aware that the injury, loss, or damage was caused by or contributed to by an act or omission of the person against whom the claim is made. And thirdly, they have to be aware that, having regard to the nature of the injury, loss, or damage, a proceeding would be an appropriate means to seek to remedy it. So let's think this through in terms of poor Mr. Armstrong from last class, right? The guy who's in the hospital, he's surgery on his ankle, and it seems to have gone awry, it got infected, and so forth. He wants to sue for medical malpractice. So the whole idea of limitations is that Mr. Armstrong has to bring that claim within a reasonable period of time after the actual allegedly wrongful act occurs. He can't delay too much. And his clock is going to start ticking when he discovers that claim, right? So first of all, of course, he has to know that something has gone wrong, right? If there's an infection in his ankle, infections often proceed for a certain period of time without any visible evidence that infection exists. So as long as he has no reason to know there's an infection, his clock has definitely not started. Then, let's say he wakes up back home, right? And he's kind of in a daze. He knows his ankle is infected. He can see the pus seeping out of his ankle, but he doesn't even remember he was in the hospital, right? Because maybe he's discombobulated from the medication or whatever, right? So if he wakes up back at home, he knows his ankle's infected, but he doesn't even remember he was in the hospital or the surgery was done on him, then this second light bulb has not gone off, right? This first one has, second one hasn't, because there's no one he can attribute that injury to. And then let's say he remembers that he was in the hospital, right? So the first 2 light bulbs have gone off, but Mr. Armstrong was told by a doctor or a nurse in the hospital that if you ever have a problem with what goes on in the hospital, you should use our hospital complaints ombudsman service, right? Like maybe someone in the hospital has told him, there's no need to engage in tort litigation over things that happen in hospitals. We have our own internal process, right? He's been led to believe that a civil proceeding would not be an appropriate means to seek to remedy it. Now, this one's a little bit tricky. Like if you're just sort of ignorant, then ignorance of the existence of civil litigation is not necessarily a defense. So this most often comes into play when something that the defendant did has sort of, it doesn't have to be intentionally misleading, but it typically comes into play. I'm talking about the third light bulb here, when something in the defendant's conduct has led you to believe that there's some other avenue of redress that you should be pursuing instead of a civil action. Okay, so only when all three of these light bulbs have gone off in the plaintiff's head has discovery occurred under Section 5, Sub 1, Sub A of the Limitations Act. Okay, so far this sounds pretty favorable to plaintiffs, right? The plaintiff seems to have a lot of ways to say that that clock was not ticking until a later point. But the Limitations Act, when it gives with one hand, it taketh away with the other. So the next couple sections kind of mitigate the plaintiff friendliness of this, right? First of all, with Section 5, Sub 1, Sub B. So a claim is discovered on the earlier of either the date when discovery occurs or the day on which a reasonable person with the abilities and in the circumstances of the person with the claim first ought to have known of the matters referred to in Clause A. Right? So what does that mean? Well, that means if this claimant really could have been expected to have all those light bulbs go off in their head on day 5, but the light bulbs didn't go off until day 20, we're going to take day 5 as the day when the clock starts ticking. Right? So it's a subtle rule because it's not a straight reasonable purpose test, right? It's not it's not just the day on which a reasonable person would have known. It's the day on which a reasonable person with the abilities and in the circumstances of the person with the claim, right? So, if Mr. Armstrong is back at home trying to recover and his light bulbs have not gone off, we're not going to say, well, a perfectly healthy, perfectly sane, untraumatized person would have had their light bulbs go off on day 5, right? We're going to compare the day when Mr. Armstrong's light bulbs went off to the day on which a reasonable person with the abilities of Mr. Armstrong and in the circumstances of Mr. Armstrong's light bulbs would have gone off. So is it foreseeable that the claimant would have known? Yes. You take the earlier day, right? So this is a concession to defendants, right? So this. Okay, so I don't know if this is going to confuse you more than it helps you, but so like this was drafted in a constant sort of balancing act between the interests of plaintiffs and the interests of defendants, right? So this here is favorable to defendants, right? It seems to say like, okay, 2-year time limit, and we're wiping out that claim if we don't start it in 2 years. But then the drafter said that's a little bit harsh on plaintiffs because some of them they didn't discover their claim. It would be unfair to plaintiffs to kill those. So we brought in this, which is favorable to plaintiffs, right? So the green stuff favorable to defendants, blue stuff favorable to plaintiffs, right? So now we have this discovery test that lets the plaintiff say, no, my clock was not ticking because I hadn't discovered it. But then the drafter said, whoa, that's a little bit too favorable to plaintiffs, right? We got to do something for defendants now, right? Because this discoverability test is gonna delay that clock too much. So they brought in this, right, which is good for defendants because this lets defendants say, even though the plaintiff didn't discover their claim, a reasonable person with the abilities and in the circumstances of the plaintiff would have. And then they do another favor for defendants over here, right? They bring in this presumption. A person with the claim shall be presumed to have known of the matters referred to in Clause 1A, which is to say these up here, the discoverability test, presumed to know those matters on the day the act or omission on which the claim is based took place, unless the contrary is proved. So that's saying, look, Mr. Armstrong, we're going to presume that you knew about this medical malpractice, this alleged medical malpractice, on the day your ankle was operated upon, right? And if you want to run a discoverability argument, then the onus is on you to do that. So that's, again, a little bit of a concession to defendants. So does that make sense? I mean, it's twisted, and it goes different directions because the drafters are kind of twisting themselves into a pretzel, trying to balance the interests of plaintiffs and the interests of defendants here. Okay, so this is used quite often in litigation, right? It's very helpful for defendants to be able to bring a limitations argument because it's disposition without trial. It's a way to knock out a plaintiff's claim without having to spend any time or money getting into the facts of what happened. It's good practice if you're drafting statements of defense to always be thinking about whether there's a potential limitations argument. So that's our first question answered, right? When the clock starts ticking. The second question is about pausing or delaying that clock, because even though we have a 2-year limitation period, that does not necessarily continue inexorably once it's started, right? There's things that can pause or even delay the clock. So the first thing here is Section 6 of the Limitations Act. The limitation period established by Section 4, which is to say our 2-year limitation period, does not run during any time in which the person with the claim A is a minor and not represented by a litigation guardian in relation to the claim. So a minor, of course, is someone who is not yet 18. A litigation guardian, we're going to talk about litigation guardians in a couple of weeks, but that's basically an adult, very often a parent, who will be is in charge of bringing that claim forward on behalf of the minor who has suffered the injury, right? And the point here is that if you're a minor, we're not going to expect you to be suing people unless you have a litigation guardian who is in a position to do that for you, right? So if you suffer a wrong before you turn 18, or if there's a period during which you don't have a litigation guardian, then the clock is not running during that period, right? Simple, question of fairness and a simple consequence of the idea of minority, right? Being that when a person's a minor, they are not expected to assiduously develop and assert their legal rights the same way they are when they're an adult. Secondly, the same reasoning applies to incapable people, right? We'll talk about incapacity in a couple of weeks as well, but this is someone who typically by reason of some sort of mental condition is not expected to bring their claim forward, just as would be the case if they were a minor. So this applies when someone's incapable of commencing a proceeding in respect of the claim because of this physical, mental, or psychological condition, and again, does not have someone who is responsible for taking care of that on their behalf. Yes, so to answer David's question, it's so that clock will not tick until they become an adult or become represented by a litigation guardian. And this can, as I say, can also pause the clock, right? So if you are perhaps capable at the time when you discover the claim, but then you have a mental condition or you're in a coma or something for some period, of those 2 years, the 2 years are not running during that period, right? We think of that countdown clock as being paused during that period of unrepresented incapacity. What happens if the wrong? Okay, yeah. So that's a good question. If it's actually the defendant's wrong, which has caused your incapacity, I mean, you're still not capable, which is I mean, the most the law can do for you is say, you're not capable, therefore that your clock is not ticking. But in a second, we'll get to the consequences of the defendant's actions in terms of limitations. Okay, so once again here we see this is plaintiff friendly, right? All of this is all about saying, look, it's not fair to plaintiffs if we keep their clock ticking when they're children or when they're mentally incapable. Then defendants are perhaps unfairly treated by Section 6 and 7, right? So we bring in another presumption, which again is friendly. That a person shall be presumed to have been capable of commencing a proceeding in respect of a claim at all times unless the contrary is proved. So that's not difficult to prove if the person is a minor. If it's a question of incapacity, then what Section 7 sub 2 means is that we're not going to look to the defendant to prove the capacity of the plaintiff at for every day during which those 2 years ticked by. We want to talk about our third question here, right? How much time is actually on these? Why is the onus on the defendant at all? Okay, so the onus is on the defendant because of the way the Limitations Act is used, right? So often the Limitations Act will be used on a motion, right? On a motion to determine a legal issue before a trial, where the defendant is the moving party seeking disposition without trial, seeking to knock out the plaintiff's claim, and the onus is on the moving party when you're motion. And also, even at trial, if it's a defendant which is seeking to prove that the Limitations Act applies in a way which strikes out the plaintiff's claim, the onus, as a matter of evidence, is on the party which is seeking to establish that. Onus is a complicated thing, which we don't have time to get into, but suffice it to say that were it not for Section 5 sub 2 and Section 7 sub 2, then the defendant would have to establish that discovery happened at the day when the accident occurred and have to prove the capacity of the plaintiff. So these presumptions just make it clear that the defendant does not have to do so. That onus is on the plaintiff. Okay, so let's talk about how long is actually on these clocks. So we've said already that 2 years is our basic limitation period, right? So most claims proceed once the clock starts ticking. You hit that 2-year threshold, then they blow up, right? That's the bomb explodes the claim. So the legislature decided at some point that the Limitations Act was a little bit too loose, right? Too many claims were being brought despite more than 2 years having passed after the incident in question, as a consequence of the discoverability piece primarily. Right, so again, we are going to do a favor for defendants here, right, by bringing in Section 15. So this is defendant friendly, right? Because even if discovery never occurred, 15 years is our ultimate limitation period. So claims which fail to be discovered or claims which are experienced by people who went into periods of incapacity, even those claims are going to die, are going to explode when they hit this 15-year limit. Okay, so statute of repose is kind of an old version of limitations and a foreign version of limitations. We don't want to get too confused by that. Okay, so this is important, right? So we have these claims where the clock has not started, typically for reasons pertaining to discoverability, and they hit this this ultimate 15-year limit, then they explode, right? So in section 15, we're not talking about discoverability anymore, right? We're talking about the day when the act or omission actually took place. So Mr. Armstrong is, under no circumstances can Mr. Armstrong start his claim against the hospital more than 15 years after the day of the surgery, no matter what he wants to say about discovery and all that. Okay, so that's so 19 is the age of majority in Ontario. I think for this, it's 19 or 18. It depends on what we're talking about exactly. Oh, which year applies to this? I'll look that up. It used to be 19. Okay, so I'm going to look that up so you know for sure whether it's either 18 or 19. Okay, so this section 15 is an effort to control and limit the number of claims which are going to survive for many years. So Daniel, it's sort of the max, but I've put quotes, scare quotes around ultimate because even here, the plaintiff still has a defense, right? So this, again, we're going back in the plaintiff's direction here, right? So it's like the legislature said, okay, so we want to have it like an ultimate period to get around all the discoverability stuff, but even then, even if 15 years have passed since the act of remission, if the person is completely incapable and not represented, right? So if you think of someone, to take Kelsey's example, but the defendant does it. So like, a defendant, someone just comes up and like clubs you with a chair in the middle of the street, and you're knocked unconscious and you're put in a coma, right? You're completely incapable in a coma for 15 years. No one steps forward to be your litigation guardian. You wake up after 15 years. We don't want to say you can't sue the defendant, right? I mean, it would be totally unfair to the. So we're still looking out for even the 15-year period, you can get through it if you are incapable as a result of this condition. And also the same applies if you're a minor, right? The person with the claim is a minor and not represented by the litigation claim, or, and this is where the defendant's conduct really comes into play. You can get through that 15-year limit if the person against whom the claim is made has willfully concealed from the person with the claim the fact that injury, loss, or damage has occurred, that it was caused by or contributed to by an act or omission, or that the act or omission was that of the person against whom the claim is made, right? So willful concealment, where the defendant is actually trying to kind of cover their tracks or mislead the plaintiff into thinking that someone else was responsible. And that includes willfully misleading the person as to the appropriateness of a proceeding, right? So if they actually were kind of intentionally trying to delude you to the effect that civil litigation cannot help you. So no, incapacity does not have to be caused by an act or omission, right? So you can get through the 15-year limit if you were incapable of commencing a proceeding because of a physical, mental, or psychological condition, and you were not represented, right? Regardless of whether the defendant caused it. And same is true if you were a minor. But then this 15.4 sub C is where we get into the willful conduct of the defendant preventing you from recognizing your claim. Yes. So the 15-year clock also starts when you are capable and have reached the age of majority, right? Because before both those things have happened, this establishment does not run because assuming you're incapable of commencing the proceeding because of your condition, right? So if you just have a physical condition, right, like you use a wheelchair, that's not going to help you as a plaintiff get through the 15-year period. It has to be a condition which renders you incapable of commencing a proceeding. And of course, if you're represented by a litigation guardian, then you can't run this at all as a plaintiff. So this is, everything in this act, every rule in this act has some kind of exception, or some kind of thing that falls on it that kind of pushes it the other way. And again, of course, we have a burden piece, right, which is favorable to defendants, right? So the plaintiff, if they want to do this and they've let more than 15 years go by, then they're going to have to prove that one of these things is the case. Okay, so we've got the 2-year limit, we've got the so-called ultimate 15-year limit. But then we have Section 16, which tells us that certain claims are just not limited ever, for various reasons that we'll look into, right? So if that happens, boo, Mr. or Mrs. Defendant, you are now being sued for something that happened a long, long, long time ago, more than 15 years even. So what claims are they which are so important or so time insensitive that we're going to let plaintiffs bring these claims no matter how long has passed? Well, they're enumerated in Section 16. And we won't go through all of them, but I'll highlight some of them, right? So if you're seeking a proceeding for a declaration if no consequential relief is sought, I don't even know when you do this, but like if there's something that's of special interest but is nonetheless significant enough to merit some litigation that happened a long time ago, maybe. So child support and spousal support, that's something which is thought to be so important to the kind of keeping people out of poverty that we're not going to apply the limitation period there. Enforcement orders, if there is a court order which requires something to happen, and you know that enforcement is this kind of extra proceeding we can engage in. So these ones are kind of interesting, kind of depressing too, right? So these are saying that if the government is suing you to get money back, then the government can do that whenever they want, no matter how long has passed. So this is about repayment of social assistance, right? Ontario ODSP or OW welfare payments. If the government says there's been an overpayment and they're legally entitled to take that position, then they can sue you to repay welfare overpayments more than 15 years after the events in question. And this one's lots of fun, right? What's this all about? This is you guys know this, right? Student loans. They do not want anyone getting out of their student loan debts ever. And the fact that 15, 20, 30, 40 years have passed does not mean that you will be able to keep the money. They are coming after you. Okay. So that is a few of those. The most interesting one of these is the one is the piece around assault and sexual assault in particular, right? Which has had a long kind of fraught history. The current law is that any proceeding arising from a sexual assault is not subject to a limitation period and can therefore be brought any number of years after. Now, of course, there's still very good reasons to act quickly if you can on behalf of a sexual assault complainant, right? The ability to make the case, fades, and it's going to be more persuasive the more quickly it's brought. But the Limitations Act does not apply. So, so the case you read, right, MK, illustrates this. So I should say, as a proviso, this case, MK is not the current law of limitations in sexual assault. The current law is Section 16 sub 1 sub H. But MK is an important case because it illustrates how serious the consequences of civil procedure can be, right? And I like it because it's a good reminder that this is not just about sort of esoteric technical questions involving the minutiae of what happens in civil actions, but like the interpretation of something like the Limitations Act can determine in a very real way whether people who are manifestly should have access to justice are going to be deprived of access to justice on procedural technical grounds like the Limitations Act. It's also great because it shows how the court develops the law, how the Supreme Court, in one of the few opportunities it's had to sort of weigh in on a civil procedure question, tries to keep our civil procedure law in tune with sort of developing social realities and with the realities of sexual assault in this case. So it was a truly horrific case of incest that was perpetrated on the plaintiff by her father, with many sort of tragic and striking and all too common phenomena, right? This sort of many people who were in a position to stop this from happening and failed to do so, and very serious mental health consequences and a dramatic effect on the plaintiff's life into her adulthood. So in this case, this incestuous sexual abuse ended in 1974, and the lawsuit was brought in 1985, right? So 11 years after the wrongful acts ceased. And it got up to the Supreme Court in 1992. And the claim is described in paragraph 10, where they basically give the facts here, right? What the nature of the suit was, damages arising from the incest and from the infliction of mental distress, as well as breach of fiduciary duty and a couple of other things. Brought against the father who perpetrated the abuse, but also against the mother on the basis that she failed to prevent it, despite knowing about it. Okay, so the old Limitations Act, in force at the time, specified a 4-year limitation period for abuse cases. So the old limitations law had different limitation periods for different types of act. So all abuse cases had a 4-year period under the law at the time, right? So prima facie, her case is statute barred. And they talk about some exceptions that were built in there, right? In the act at the time, she could have got around it by saying that she was a mental defective or mentally incompetent, and she doesn't do that. The argument is brought on the basis that this is paragraph 21. The appellant argues that her case of action did not accrue when she went through a form of therapy, because her psychological injuries were largely imperceptible until later in her adult life, and thus not reasonably discoverable until she was able to confront her past with the assistance of therapy. Right? So it's worth thinking through what's happening here, right? So she suffered this abuse while she was a minor, and it's agreed between all parties that the clock was not running until she reached the age of majority, right? Because the act at the time also paused the clock during the period when someone's a minor. The respondent, the perpetrator of the abuse, wants to say this limitation clock started running when she turned 18. And the Supreme Court could have tried to tackle this by kind of parsing the language of these sections they had at the time. Instead, they take a sort of a broad, purposive approach. I actually really like what the court did here. I think it's a really kind of elegant way to move the law forward. And they talk about the purposes, the overall purposes of the Limitations Act, right? So it's a purposive interpretation, where this kind of method of reasoning, where you say, okay, well, why do we have this rule in the first place? And given what we know about why we have this rule, what does that tell us about how the rule should be applied or not applied on these specific facts? So this is kind of old-fashioned language here, right? There's this idea of certainty and repose. They say is one of the reasons why we have the Limitations Act, so the defendant can eventually rest and not fret themselves about the fact that they'll be sued about something that happened a long time ago. The diligence rationale. But really what it comes down to is evidence, right? I mean, the real purpose of the Limitations Act, and this is the one which has really survived into modern law, is the second rationale here, the evidentiary rationale, right? The only good reason we have to strike claims out and say we're not going to adjudicate them on their merits is the fact that human recollection and evidence being what it is, after a certain point in time, we're so likely to get it wrong that we shouldn't. It's not reasonable to even try. Okay, so in this case, they say none of these rationales for the Limitations Act seems to be a persuasive reason to deny this particular plaintiff the right to advance her claim, and it's it's a kind of it's a type of legal reasoning that you'll find in appellate cases, right? We're going through the purposes of the rule and showing why none of those purposes, rationally interpreted, should lead to a particular outcome on these particular facts. Okay, so paragraph 25, they move to a different type of reasoning, and they talk about why it is that tort claims arising from incest are special, right? Why is it to treat these claims differently than we would other civil actions? Can anyone give us some of this reasoning about what makes these particular claims special and unique and requires the law to treat them in a different way? Starts at paragraph 25. Anyone able to help us out here? What makes these claims special? Because any defendant is going to be in a position to say that my ability to access evidence has faded. So why isn't that solicitude for evidence so persuasive here? What's special about these claims? Use the phrase delayed damage. What does that mean?
Hi, so essentially it's you wouldn't recognize that it was wrong until, well, in this case they say until you go to therapy, but there's a dissent that says that might not be legitimate, but anyway, essentially that you wouldn't recognize it right away.
Yes, exactly, right? The delay, and we heard about the same idea in this case from privilege, right? Remember the MA versus Ryan case, which made a very similar point about assault and about the role of therapy in sort of responding to suppressed memories. So it's a similar kind of idea here. So that's important. And then so there's this, as Daniel says, there's this idea of misplaced guilt and the nexus, right? So even once the victim recognizes that they're suffering damages, and so once they recognize that they have these symptoms, they're experiencing these damages, and they know what happened to them, they may not recognize the connection between them. Right, and that's what they call the nexus. So if you don't perceive the nexus between your damages and the action in question, then you're not in a position to think about blaming anyone or bringing a lawsuit. And finally, the social context piece, right? One cannot ignore the larger social context that has prevented the problem of incest from coming to the fore, specifically these powerful taboos, and which have conspired with the perpetrators of incest to silence and maintain a veil of secrecy. Which again comes back to the guilt idea that Daniel was mentioning, right? That if people, to the extent that people blame themselves and their inclination to blame themselves is fostered by the way society perceived these things, again makes it less reasonable to hold the plaintiff to a strict standard, the same strict standard of moving forward quickly that we would expect of plaintiffs in other types of cases. Okay, so they apply this to the present case. They have to do, some sort of intellectual gymnastics to find a way to avoid application of the Limitations Act here. That's not of interest to us so much as what this says about the nature of sexual assault, and to some extent assault generally. So this has played out over the years, right? And this was the law until 2016, right? Where we had this section 10, where they were trying to again draw a line, a very sort of subtle, complex line between, how far, what extra accommodations are we going to provide to plaintiffs in assault and sexual assault cases, right? And they're trying to compromise. In 2016, they decided to just add it to Section 16, right? So now we don't have to get into whether there was a power relationship between the parties or possession of trust or authority. All sexual assault is exempt from limitation periods. So it's still controversial. I mean, some people say, this means that people will be falsely accused and falsely held responsible for things they didn't do. But on the argument on the other side has carried the day that it's just not reasonable to apply any of this stuff to sexual assault. Okay. So I think that's what I wanted to say about the Limitations Act. It's not an easy one, right? And I think its complexity, as I say, springs from its effort to kind of walk on both sides of a line, and its tendency to sort of lean in one direction and then lean back in the other. But I mean, as I say, if you take away one thing and you go into civil litigation practice, take away the fact that you've got to ask potential plaintiffs about dates, and you've got to, 9 times out of 10, you can cover your ass as a plaintiff's lawyer by simply making sure you don't let this 2-year period go by, because you're totally safe. Like all the rest of this is important in particular cases where it arises, but you are absolutely guaranteed to be have your nose clean if you make sure that you bring every claim within 2 years of when the events in question actually occurred, assuming that's possible. So despite that, this is something that goes wrong for plaintiffs' lawyers all the time, right? It's a very, very common cause of professional discipline and of client lawsuits. So this is LawPro is the professional indemnity insurer. Once you're called to the bar, you will pay them a few $1,000s a year for malpractice insurance, which means that if your clients sue you for screwing up their cases, then LawPro will defend you and pay those clients, your former clients, if you have in fact caused them loss. So time management is the problem, is the source of 41% of client claims against lawyers. That's not all limitations, but a big, big chunk of that is, right? So just lawyers failing to keep track of time and letting claims expire and die because they were not brought forward quickly enough. So I think last time we talked about tickler systems and the importance of that for good practice, to avoid missing deadlines once litigation starts, but perhaps more importantly, to make sure you start your litigation as quickly as you can if that two-year limit is coming up. Okay. Let's look at participation questions. So these were probably too complicated for you. There were very complicated questions for you to tackle before we did this class, but let's look at them now. Okay, so here you're on for you're on for Subway. No, sorry. Okay. So Bob's Burgers has it's this commercial rivalry, right? We got these two wacky restaurants, and Bob's Burgers puts up these billboards with these false claims that Steve Subs has put rat poison into their bread. This is a completely untrue fabrication, but more than 2 years have passed, right? And we've got our Limitations Act. We know 2 years is our general golden rule limitation. What can this should be Bob. Sorry, there used to be a restaurant called Beans Ladle. It was before your time. People here when Beans Ladle was still here. It was at the corner right outside the law school, so we had fun with it. But it's gone now. So I tried to change everything to Bob's Burgers, but I missed this one. Anyway, the claim, it seems it should be statute barred, but yeah, no, that was just a screw up. So what could prevent it from being statute barred, right? What can Steve Subs do to get out of that limitation period? And this, I think, is the most natural response, right? Because the anonymity. Well, which section? Can anyone tell us, like, which section of the Limitations Act would you plead if you were on for Steve Subs and you're trying to say this claim should not be statute barred? Which section of the Limitations Act does this connect to? Someone's defamed you, but they've done so anonymously, meaning they don't have their name on it. You can't trace it to them. Which section number in here is going to makes that relevant? Okay, yeah. So it is 5 sub 1 sub A sub 3 that I'm looking for. Right? If someone has defamed you or someone has done anything against you anonymously, they completely covered their tracks, then you are not going to be able to. You can't be expected to sue them, and it would be unreasonable to have this countdown timer ticking and blowing up your claim, because how could you have possibly sued them? You didn't know who it was. You have not discovered a claim if it was anonymous. You have not discovered it until the day on which you discover the anonymity. You discover the true identity of who was behind that wrongful act. Okay, the rest of these things. So this, interestingly, does not matter, right? That settlement negotiations can happen prior to any claim being brought, and in fact, it's good practice. It's basically negligent of you as a lawyer to not seek opportunities for voluntary resolution before bringing a statement of claim, because your client will always be better served if a simple letter to the other side gets them to give your client everything they want without having to pay you to draft and file a statement of claim. So parties do seek settlement before they file, but the fact that settlement negotiations are ongoing does not stop the limitations clock from ticking. So you have to bear that in mind as a plaintiff, right? And you're going to want to say to the defendant, look, let's see if we can resolve this. Try to do that within 2 years of the clock starting ticking. You can also get the defendant's consent to waive the effect of the Limitations Act on the basis that settlement's being sought. But the mere fact that you're talking about resolution does not stop the clock from ticking. Yeah, and no, neither does any of this, right? So we don't care what the intent of the defendant was, and we don't. So the legal advice, getting incorrect legal advice, does not put you within the bounds of this, right? This, as we said, get subsection 4 here, does not. More pertains to things where the defendant has done something, some remission, which has led you to not understand that civil proceeding would be the way to go. Okay, so here, which section? Okay, so we're assuming they're anonymous and could not be traced back to Bob's. Okay, so that's the question we just asked, right? That's the one I just asked. If you were resisting this, you would do so on the basis of 5 sub 1 sub a sub 3. Okay. Question 3, consequences of default. This is just a call back to last class. And default judgment, right? Is where the defendant takes no action. The plaintiff notes the defendant in default, and then they're sort of in this purgatory state, but they can get out of it. You can have default set aside, and if you do so, then the defendant can then go on, gets back on the road, and they can go on to win at trial. So this is the answer I was looking for here. That brings us to the end of limitations and brings us to the end of disposition without trial, right? We've now gone through these 8 techniques that are available to a litigant to win a case completely without having to go all the way to trial. So that takes us into Unit 10, which is about arbitration. So I'll just say that topics 10, 11, and 12 are all part of alternative dispute resolution, right? If you hear the phrase alternative dispute resolution, which hopefully you've heard by this point in law school, that usually means arbitration, negotiation, and mediation. So in a way, it's a kind of a funny choice of words, alternative, because it's actually much more commonly used than civil litigation is. The vast majority of claims of any type or disputes that could give rise to litigation are resolved consensually, typically through negotiation. Nonetheless, we talk about it as the alternative. Also, of course, it predated civil litigation. But anyway, so some people say it should be appropriate dispute resolution, but alternative is the word we have. Considering ADR and appropriately deploying ADR on behalf of your client is an absolutely core part of competent legal practice, simply because there's no way that you can cost effectively and efficiently advance your client's interests unless you're always alert to opportunities to secure and protect those interests without having to litigate. And the rules of professional conduct emphasize that. So here's our definition of competent lawyer. Let's just advance that. Don't have time for tedious animations. So you have to be a competent lawyer, apply relevant knowledge, skills, and attributes in a manner appropriate to each matter. And the application of appropriate skills includes alternative dispute resolution. And then 3.2-4, you have to consider the use of alternative dispute resolution, ADR, in all cases, and inform the client of ADR options. Okay, so the whole next week of class, we're going to be talking about negotiation and mediation. Arbitration, we'll discuss very briefly. So arbitration is privatized adjudication. Right, so arbitration is adjudication insofar as in an arbitration, you give a third party the right to impose a resolution on you. just as if it were a judge. But arbitration is privatized adjudication because that third party is not a judge. They are an individual or a panel who has been granted that adjudicative authority by contract, right, to the contract of the potential litigants. And of course, they'll be paid to do that work, and they'll do it in private. And the way in which they do it, the way in which an arbitrator works, is not necessarily in line with the rules of civil procedure. In fact, typically it's not. The parties to an arbitration contract can have wide latitude to choose the procedure by which their dispute will be resolved. And typically, the procedure they will choose is one which is significantly less onerous and time-consuming than the conventional civil action. Right? That's one of the chief reasons why people choose to arbitrate, is because it gives you a guarantee of a resolution, whether or not you can agree, and it gives you that resolution in a cheaper and quicker way than the conventional civil action would. So although parties design arbitration and arbitrators through contract, we do have a statute, the Arbitration Act, which is relevant. It defines what an arbitration agreement is. Any agreement by which two or more persons agree to submit to arbitration a dispute that has arisen or may arise between them. So that's important. Arbitration, parties can sort of, once they already realize they have a dispute and they know litigation is a possibility, they can choose at that point to bring in an arbitrator as a quicker and cheaper way to resolve it. But arbitration can also arise through a contract signed before any dispute arises, right? So if you have purchased any goods or services in Ontario within the last 5 or 10 years, then you are already a party to at least a half a dozen, probably 50 arbitration contracts, because the boilerplate terms you agree to when you download software or buy many products and services will include an arbitration clause stating that if you have any problem with the product or service, you cannot sue the corporation that sold it to you. Instead, you have to go to arbitration. Right? If you look at your cell phone contract, you'll probably see an arbitration clause in there for that reason. Right? So arbitration can always arises by contract, but it can be a contract which is signed by the parties long before they even knew that any dispute would arise, in addition to being a contract that arises after the dispute arises. So under the arbitration, the core of the Arbitration Act is saying that no court shall intervene in matters governed by this act, right? So if, and the state comes into play here, right? So if there is an Arbitration Act which governs a dispute and you try to sue about it, then the defendant will go to court and say, stay that claim, knock it out of the park, because, not knock it out of the park, knock it out of existence, because we've got this binding arbitration agreement that that person signed when they got their cell phone contract, or that they signed last month, and therefore the civil lawsuit is stayed, killed. Okay, so that's what it does. And so the court will very, very rarely, only in a very rare and narrow circumstances, will a court interfere if there's an arbitration agreement in place. But there are a few things, right? So, if you were under legal incapacity when you enter that agreement, we won't talk about the grounds for invalidity. If the arbitration agreement is totally stacked, like if the person who's supposed to be the arbitrator is in a blatant conflict of interest because they're taking money from one side instead of the other, or something like that, there are narrow bases on which to get out of these. We don't have time to get into them. But the takeaway is that people are allowed to sign arbitration agreements, and courts respect them in the sense of not letting people commence civil actions with regard to matters that are subject to arbitration agreements. Okay, so at what point would you attempt to stay the proceedings? So as soon as possible, right? If you are, if you represent Rogers and you know, as you would, that all of your customers have signed this arbitration agreement, whether they knew they signed it or not, and someone tried to sue you, you would, as soon as possible, bring a motion to stay that under the Arbitration Act. And as for Kelsey's question, so this is interesting. This and it's a kind of a complex issue. In some arbitration cases, like in family law arbitration, which is very, very popular among, in particular, like high net worth people who want to keep their divorce out of court, they'll hire an arbitrator, and they're represented by lawyers. So the arbitration agreement will identify a particular person who will be the arbitrator. In the case of like these consumer boilerplate arbitration clauses, there will be some small print in there about who the arbitrator will be. Like it'll be selected by the American College of Arbitrators. And there's different ways to do it. It's controversial. It's an interesting topic, actually, if you want to do some research on it, because when it comes to arbitration that corporations use to evade lawsuits and evade class action lawsuits by consumers, they have a strong interest in being able to control as much of the arbitration process as possible. So there's a live debate about whether that process is consonant with the basic expectations of plaintiffs, that they should have some avenue of redress which is not totally controlled by the defendant. So it comes up quite often in the States. A little bit less here because, but it's still a thing. Do you have to have a certain qualification? No. So you could, if you and your civil procedure study buddy were in a civil dispute about who was supposed to provide the notes from the October 29th lecture, then you could sign an arbitration agreement. You could say, well, we might have to go to court about this because it's a really big deal, but we want to avoid that. So we're going to choose Bozo the Clown to arbitrate this for us. And that would be your right. I mean, it's your dispute, right? You'd be allowed to resolve it and drop it completely. So it sort of follows that we're going to let you agree to arbitrate that in a way you like. There are exceptions where there's like a lot of pecuniary bias that makes that person completely unable to provide even the barest fragment of procedural justice. We're not going to get into them, but there's wide latitude to parties to choose the arbitrator and choose the procedure that arbitrator will use. Okay, so I think maybe we'll leave it there, and happy Halloween.